Thank you for coming back and joining me for Section 2 of Module 4. You're almost done with the pre-course modules. For this section of Module 4, we're going to review some of the policies and procedures that pertain to HOP1. And many of these policies and procedures may be things that your agency already has in place, but we'll talk a little bit in more detail about the various components of these policies and procedures. So let's take a look at key rental assistance program policies and procedures. And they include the following. Client eligibility. So client eligibility should be clearly outlined as far as what makes a client household eligible for the rental assistance program being offered. Primary in this, of course, will be the HOPWell eligibility standards set by the U.S. Department of Housing and Urban Development as it relates to HIV status and income. Additional eligibility considerations may be adopted locally and relate to items such as residency within a specified or designated area of the program as serving extremely low-income clients. Program focus may also dictate eligibility, and this may be an agency-by-agency case, but as in the case of programs that target specific populations, such as the chronically homeless, persons with substance abuse issues, or others. In addition, client income must be verified at least annually, so rental subsidy amounts and residence rent contributions should be recalculated accordingly. When a client does not qualify for a program targeted to a specific subpopulation, your agency should make every effort to connect those clients with programs for which they do qualify. Next, let's look at the intake plan. The intake plan should include various components, and the first one is a written description and timeline for bringing a prospective client into the program, as this will help program staff gather information more effectively to assess clients' needs, evaluate barriers to housing, and identify appropriate housing and support services, and also convey other information the client needs to achieve housing stability. An intake plan should also include a referral and waitlist section, and this can include a written process for referrals to other programs. The management of a waiting list for rental assistance will help the client program ensure equal treatment and access. And lastly, the intake plan should also include a client participation agreement, and this is essential to clarify a client's responsibilities while participating in a rental assistance program. It should outline the availability of and process for accessing case management or other supportive services and the importance of participation in these types of services. The client participation agreement should also include requirements related to notifying the program of changes in income or household composition, timely payment of rent to landlord, and any other program changes or requirements that require action by program participants. Additionally, this agreement should clearly specify that the termination of the lease will lead to the termination of the rental assistance. So within your program's policies and procedures, there should be a section dedicated to procedures as they relate to termination. And this could be termination due to violation of program requirements and termination in the event of death of the HOPWell eligible participants when there are surviving family members. These procedures should be reviewed and signed by the rental assistance program participants at intake, and the signed document should be kept in each participant's file. Termination procedures should include written notice to the participant with a clear statement of the reasons for termination and the opportunity for a participant to review the decision and present any written objectives. Prompt written notification of the final decision should also be sent to participants. We also want to discuss program or house rules, and these should be clearly written and easily understood by all clients. Legality of program rules should also be reviewed to ensure that they are consistent with all applicable federal, state, and local laws. Additionally, programs may want to allow for client input into the rules, as well as a process for periodic review and revision. Topics such as tenant conduct, substance abuse, illegal activity, and any additional rules should be discussed within these written rules. And lastly, your agency should also have written procedures to address emergencies and grievances. This involves procedures that outline the steps to be taken in the event of a psychiatric or medical emergency, accidents, or other serious incidents affecting program participants, visitors, or staff. The rental assistance program should also have clear written grievance procedures for addressing resident grievances with other residents and/or staff. These procedures should be available to both staff and residents. Now let's take a look at the second part of our policies and procedures discussion. When discussing the housing search process, your agency should have policies outlining the correct process to be taken when conducting this kind of search. This should include information on permissible unit size, maximum rent allowed, and the area in which a client may look for housing, if applicable. Clients should also be informed as to the maximum period of time allowed for locating housing and be provided the applicable unit utility allowance schedule for the area. Additionally, many programs provide a simplified habitability standards checklist to help clients eliminate units that would not pass a HOPWA habitability standards inspection, which is required before signing a lease. When we're talking about move-in prerequisites, program staff should provide clients with guidance and evaluating units during a housing search, as well as verifying that the unit meets occupancy and HOPWA habitability standards. Staff are also responsible for reviewing leases prior to clients signing them and calculating resident rent contribution and subsidy amounts. As part of the procedures for move-in prerequisites, staff need a landlord contract that can be used when a client is able to rent a unit. Staff must also obtain an IRS W-9 form, request for taxpayer identification number, and certification on file, and set up a payment account. Another policy is the housing suitability. In order to ensure the compliance with HOPWA habitability standards, the rental assistance program staff should have a formal process for inspection of rental units prior to authorizing client lease execution and move-in. The process should include subsequent inspections at least annually during assisted occupancy. And that leads us to occupancy standards, and this refers to the guidelines set by a housing program governing the number of bedrooms allowed for households of different sizes and compositions. HOPWA rental programs have some flexibility in developing specific occupancy standards, as long as the standards do not violate fair housing requirements and comply with federal, state, and local fair housing and civil rights laws. The primary intent when developing occupancy standards for the rental program is to provide for the smallest number of bedrooms needed by a household without overcrowding. It is acceptable to make allowances for special needs or circumstances, but the standards developed by the program must be applied equally and fairly to all program participants. Once a client finds a unit that is suitable and meets program's rent standard, HOPWA habitability standards, lead-based paint, and rent reasonableness guidelines, the lease must be reviewed and approved by program staff. Rental assistance programs may decide to develop a preferred lease format that landlords must use, or they may allow landlords to use their own leases, as long as the leases do not contain provisions prohibited under the program. And of course, before the client signs the lease and payment of rental assistance begins, a contract of participation agreement must be signed between the administering agency and the owner of the units in question. The landlord contract should not list the HOPWA program by name, nor should it refer to the HIV or AIDS program generally. The landlord contract should be fully executed and signed by the landlord and designated agency staff. A contract of this type should be executed for each unit occupied under the rental assistance program, and a copy should be placed in each client's individual file. Congratulations! This concludes Section 2 of Module 4. You may now proceed to the next section of this module.